Hey Lisa, we're live. Morning, everyone.
Good morning, everyone. Welcome to today's webinar here on the TSD platform. It's really great to see that we have quite a good attendance today. A very warm welcome to you, John, who will be taking us through an exclusive labor law session, which will focus on the recently publishing of the Code of Good Practice on dismissals under the LRA. This session will definitely provide crucial insights into how we will handle the changes of the impact in our workplace regarding the discipline management. I think we can jump into it. John, welcome again, and everybody enjoy the session.
Thank you very much, Lisa. I appreciate it. Good morning, everybody. And Krista, thanks for setting this up. Well, today we take a look at a very, very important topic, which is dismissal. We've had a particular dispensation for, goodness, more than 2 decades. And what we do now see is a new draft code on dismissal, which has gone through NEDLAC and has been published for commentary. Colleagues, before I put the slides up, just to give you a bit of background, the new code, of course, takes a look at modernizing law. It takes a look at giving one point of reference. And I think for you as TSs, I want to just start off by making you alive to the fact that the disciplinary process is a bit of a nuanced topic, because when we look at equal treatment under the LRA, but also just in general, we understand that your temporary assignees, particularly those that are placed with your clients for more than 3 months, should be treated on the whole not less favorably. And in disciplinary matters, it often happens that with consistency, considerations of fairness, you should generally align your dismissal processes with your client's disciplinary code in order to ensure equality and equitable treatment. So from the outset, I want to say, as we go through the slides today, and I'm going to do a bit of AI on the back end, Lisa has just reminded me about AI and the application of this, but I want you to think about how this code can be used by you in the context of equal treatment, but also to differentiate you in the eyes of your client, because the more you can be customized and client-centric, the more your clients will appreciate and value what you do for them. These slides will be made available to you, and I'll send them shortly after the session. I'll send it to Krista. So I'm just trying to get my slide deck on the screen, and then we can get going. You're welcome to post any questions or commentary in the chat box. I will take a look at it from time to time. And yeah, really just enjoy the session. I'm going to try and keep it succinct. I'm just trying to actually find my, I apologize, my laptop's not very responsive. Just trying to find the actual slide deck. Maybe just while I'm trying to find my slide deck, I want to also let you know that this has not yet been promulgated. It's a draft code of practice. What does that mean? It means that it was published for public comment on the 21st of February. Okay, and it was published in the Gazette on the 21st of February for 60 days commentary. So off that particular basis, 60 days obviously then expired on the 21st of April. So the Department of Employment and Labour are busy pulling together the submissions in respect of this code. And I believe in the next 2 weeks to a month, we will get the final version of this code gazetted for implementation. So make sure that you are proactive, ensure that you are aligned and that you are ready to implement as soon as it is promulgated. So, colleagues, the new Code of Good Practice on dismissal, as I said, is a draft. And effectively, if we take a look at it, the proposed code is very, very much more comprehensive and structured than the current code. Colleagues, all of you will be familiar with Schedule 8 of the Labour Relations Act. Schedule 8 of the LRA currently covers dismissals for misconduct and incapacity. What we see here is a full revision of Schedule 8 of the LRA, and it's much more comprehensive. It contains a lot more guidance, and it is fully structured. So before we get into the detail, I want to just prepare your minds for why they've gone through this process of modernizing and updating it. So the major changes in Schedule 8 in the Code of Good Practice, it's better organized. In other words, it is structured more effectively. It's got more detailed procedures. You'll see as we go through it, there's more detail on areas like unprotected strikes and how to deal with that. They've included operational requirements into Schedule 8 of the LRA. So you'll remember historically, Schedule 8, as I said, only covered misconduct and incapacity. They've now pulled operational requirement guidelines into the code as well, so that all three types of dismissals are in one particular place. Then there is clearer guidance in terms of more codification and some additional protections. In some cases, business is given a bit of leniency, and we'll identify that. For example, in probation, you'll see there's a bit more leniency in respect of disciplinary inquiries and the formalities that they are trying to decriminalize and make it less formal. And just to give us more, as business, more agility, especially small businesses, colleagues. Now, interestingly, they don't define small businesses. They just talk about small businesses being businesses that cannot be reasonably expected to comply with all the detailed laws, okay? So that is why the proposed code was tabled and discussed. If we look at the right-hand side, the new code, as we take a look at it, has got completely new provisions in certain areas. For example, when we take a look at the procedure that is necessary to be followed, for example, with unprotected strikes, ultimatums, when we look at Section 189, they give more detailed procedural guidance, which is great because sometimes we're not always sure exactly what the legal obligations are. Secondly, probation, as I said, they make a bit easier. In fact, they make it a lot easier. We'll look at that. But interestingly, when they talk about more senior people and professionals, they're going to get less protection than usual. So they're basically saying they want to free up the CCMA and the dispute resolution forums. And part of that process is to make it less attractive for senior people and professionals and less protection for them in the context of dismissals. Then, for those of you that have ever come across employees that you felt were just not matching your company's culture and values, and you didn't quite know how to deal with them, well, they've written incompatibility into incapacity. So they talk about the fact that if people's cultures and values don't, find any form of overlap or unity, you can use incapacity to dismiss off the basis of that employee not being compatible with the team or with the company. We then have a comprehensive retrenchment procedures that I refer to together with a template. They've given an actual template for Section 189(3) retrenchments. And then, as I said earlier, specific dispensations for small business. So I don't believe they did as well as they could. I think they could have made a lot more meaningful changes, but it's a start, and we'll get stuck into it. Overall, I must tell you, though, that it is good for business in most instances. Obviously, there are there's a two-edged sword. Sometimes the employees get a better deal, and sometimes business do. But overall, I really think this is good for business. So, colleagues, when we look at the structure of the Code of Good Practice on Dismissal, which is really Schedule 8 of the LRA, you'll see as we go through it, in terms of the structure, the current code is less structured, whereas the new code, the green, is a lot more structured and a lot more, it flows a lot better. Then if we take a look at the purpose of the Code of Good Practice, the provisions say that the purpose of the Code of Practice is to provide guidance on legal obligations. So originally it said, the code is there and, employers need to be aware of it, but they've now put the word guidance in and said, well, if you depart from this, you're going to have very, very justifiable reasons. Small businesses, as I said, they had very limited protocols applicable to small business in the current Schedule 8. You'll see now when we get into the detail, colleagues, small business is being given a bit of a gap. And you see this theme regularly repeating itself. So, for example, under the Employment Equity Amendment Act, you'll remember now that employers employing less than 50 employees are excluded from the provisions of Chapter 3 of the Employment Equity Act. And here we see in the Code of Practice of Dismissal, they're saying small businesses should not be burdened with a whole lot of the formalities and the resources required in the process of dismissing people. It doesn't mean you can do it unfairly, but they want to give you more flexibility and more agility. The green area then goes into a lot of detail on misconduct dismissals. So we will take a look at misconduct dismissals, obviously in the yellow, probation and incapacity. I want to just say now that for those of you who haven't yet looked at the Labour Law Review going through Parliament at the moment, the proposed amendments to the LRA include an absolute 3-month freedom to dismiss new employees. I want to repeat that. The Labour Relations Act amendments that are making their way through Parliament at the moment include a proposal that when you employ a new employee on probation, that for the first 3 months, you can dismiss them pretty much without any significant process requirements. All that is protected during that 3-month period is you obviously cannot dismiss people because of their race, their gender, their sexual orientation, etc. But outside of that, you're going to pretty much have free rein in the first 3 months. And I think as TES, you need to decide how you're going to use that in order to, enhance your proposition to your clients. In the dark orange, you then see the whole new section in the Code of Practice on operational requirements. Okay, so it goes into a lot of detail on selection criteria, consultation under 189 and 189A, the role of the trade. Under Section 16 of the LRA, in other words, private and confidential information. Colleagues, severance pay, as you know, severance pay, another part of the Labour Law Review is to increase severance pay from 1 week per completed year service to 2 weeks per complete severance pay. When it does eventually come through and towards the end of the year and they double it from 1 to 2 weeks, it will only be going forward, not historically. And then colleagues, they talk about re-employment, the use of language, and timeframes. So you can see that the Code of Practice on Dismissal is a very detailed document. We're obviously not going to have time to go through all the detail, but I am going to send you the slides, as I said, and I will send you the actual Code of Good Practice as well, the TESD. So let's get stuck into it. Remember, colleagues, of course, there are only three types of dismissal, right? Misconduct, incapacity, and operation requirements. So this whole dark orange area is a new inclusion in the codes. Previous only had the green, and which was misconduct, and the yellow. We now have all three in one place. Now, I want to just ask you to start thinking about, colleagues, the rules of natural justice are universal rules that have to be present in order to ensure fairness. Now, when we go through this code of good practice and the changes, remember what they're trying to do is they try companies, especially smaller companies, an opportunity for agility, flexibility, and decriminalized procedures. Now, you might say to me, John, what do you mean by decriminalized procedures? Can you imagine at the moment, for a disciplinary inquiry, and certainly for a dismissible offense, you have a preliminary investigation, you then gather all the evidence, you then decide on suspension or not, and if it's justified. Once you suspend the person on full pay, you then have to issue a notice to attend a disciplinary inquiry with generally at least 48 hours notice, often longer, because they ask for postponements, etc. You then have the disciplinary inquiry, and during that inquiry, it's an incredibly formal process. You've got your chairperson convening the meeting, identifying the parties, having their rights established. You then have the chairperson asking for a pleading of guilty or not guilty. Then you have opening statements, evidence in chief, cross-examination, re-examination, closing statements. You see, that is a criminal underpinning. It's a criminal-based procedure. And it's often resulted in organizations being found to have unfairly dismissed employees because they didn't tick maybe every one of those boxes. So one of the things I want to do is, especially for smaller businesses, but generally to try and make it more of a dialogue, more of a listening and a dialogue and a reflection than a criminal justice type process. So if I had to say to you, think of your disciplinary code and the right to be heard, the Audi Ultram Partem rule. We're all very familiar with the Audi Ultram Partem rule, which is here the other side. Now, what would this look like in a decriminalized, more simple and agile disciplinary code? You know, is it leading evidence in chief? Is it cross-examination and re-examination? Or could it literally be, let's sit down, we'll tell you what we're concerned about as a business. We might call a witness or two and you tell us about your response, and then we consider the evidence. You see, that's an example of how you can still comply with the Audi rule, but not necessarily go through all of the rigmarole. What about this one? No one should be the judge in their own case. You know, the rules of natural justice, nemo iudex causa sua, says that you can't be the complainant and the chairperson, you know, especially in a disciplinary potential dismissal. However, some organizations don't have the luxury of having other departmental heads and other trained people to come and chair their inquiries. So maybe the person chairing the inquiry doesn't have to be of the same or similar level or high level. Maybe you can have someone else chair the inquiry if you don't have those resources in your organization. What about 48 hours notice, colleagues? Like, who said 48 hours? Why can't it be reasonable notice based on the type of the offense? For example, if Krista arrives late for work, or if Krista has been absent for 5 or more days, why on earth would I give her a suspension letter and a 48 hours notice to attend an inquiry? It's a simple matter. She hasn't been at work. Why can't we have a same-day hearing later that afternoon or maybe the next day? You see, I'm challenging your thinking because as we go through the amendments, you'll see that they are giving you a degree of flexibility to innovate in this environment. Okay, so I'm just saying, remember, the code of practice doesn't do away with these particular rights, but what it does give you is an opportunity to decide how to apply these rights in a more efficient and optimal manner. So let's get stuck into the actual content. And as I said, I'll send you the full code of good practice. You can go through it. At the end of this, I'll even give you an example on how to use AI to assist you in potentially revising your code. But let's start off, colleagues, with the code of good practice. And we start off with part A, which is the introduction to the code. Now, remember, this covers misconduct, incapacity, and operational requirements, you'll see. So for the first time, we have all three, as I said earlier, in one document in the new look Schedule 8. And you'll see it provides guidance. In other words, it gives you insight, but it doesn't mean it's law of itself. You could have nuances and you could have certain deviations from this, but if you do, then make sure that it still complies with fairness. You'll see also in this introductory part, it talks about how to interpret these codes, and they say each case is unique. So my example with Krista just being absent, I mean, that doesn't require extended processes compared to a forensic audit, which could take weeks or even months. So each case is unique. And then it says, in certain circumstances, the number of employees in an establishment may warrant a different approach. So they're starting to say to you, listen, look at your number of employees. It then says the key issue in dismissals, and when we look at disciplinary and incapacity and operational requirements procedures, the key issue is mutual respect. So they're saying, listen, maybe the procedure, as important as it is not as important as maintaining human dignity and mutual respect. And then they continue and they say, at the same time, companies must run their businesses. And they say employers must have the opportunity to ensure the expeditious resolution of disputes. So these yellow areas are the new amendments and the new inclusions. You know, they're saying business need to have an agile process. And then right at the bottom, the code says, as part of the introduction, we're not going to use these big legal terms all the time. We're going to use terms like retrenchment. You know, we've always been so fixated when we do a retrenchment, we call it, contemplated dismissals for operational requirements, because we're so scared we use the word retrenchment because it looks like we've made a decision already. And they're saying, no, use the words that everyone can understand. You know, obviously you still have to comply with law. Now, colleagues, what's interesting is, as part of the introduction, they then immediately, after that opening preface, they go to small businesses. And as I said earlier, they haven't defined what a small business size is, but what they have said is that a small business, if in applying this code, should not be interpreted as being required to comply with obligations that are not practical or feasible. Now, you would know, colleagues, for example, that practicality and feasibility is based on your available resources and your available time. And they're saying that small businesses are under pressure, more so than medium and large businesses. And any person determining the fairness of a dismissal must take into account the circumstances of the small business. In other words, a labor court, an arbitrator, and any other party that is adjudicating whether or not you dismiss someone fairly for misconduct, incapacity, or operational requirements, they've got to take a look at your business realities. And I believe for many of you, on your client's premises, you might have 30, 40, 50 people on a site. You don't have massive resources to invest in these disciplinary inquiry processes, chair people, etc., etc. And I believe that you could potentially structure your disciplinary procedure and code to take cognizance of that. It says, for example, small businesses cannot reasonably be expected to engage in time-consuming investigations or pre-dismissal processes while at the same time keeping the business going. It should also be kept in mind that small employers generally do not have human resources departments that are staffed by people with the legal skills and experience in these matters. So I hope that you're starting to get a picture of where the code is going. Now, if we take a look at unpacking the words practical, feasible, etc., the word practical means capable. In other words, there's a distinction between practicable and practical. Practicable refers to something that's physically possible, whereas practical refers to something that's sensible or worthwhile. And they use the word practical, not practicable. So they're saying to you, use processes, use resources, but only in that it's sensible, given the circumstances that you face. And then feasible means that it's capable of being done, given the circumstances. In other words, it should be technically and economically possible. So colleagues, here are examples of factors that could be indicators of you being justified in using more agile and simple processes. So for example, you don't have significant human resources, labor relations resources, you don't have massive admin capacity. You incur massive costs if you had to go by the book all the time. You know, there's maybe a systemic risk in terms of, you just don't have the structure in your business and the knowledge and the know-how to attend to all these complexities in the usual legalistic criminal-based approach. And then obviously it's difficult for you to recover after these incidences. So let's just recap. The first thing is they're saying in this code, they're saying this is a guideline. We're covering all three types of dismissal. We put a premium on mutual respect and expeditious resolution of disputes, but we still will not allow unfairness. So somehow you need to find a balance in order to treat employees fairly, but still run a business effectively. And then they say, notwithstanding that, a small business has got even more latitude, because they should be allowed to run their businesses and should not be required to do what is not practical or feasible. So it's going to be an interesting thing to ask you later on. And do you see opportunities to amend your disciplinary code, your incapacity process, and your retrenchment approach? So what the code now does is it goes to part B. So part A was the introduction and preamble. We now go to part B. So when we talk about dismissal, colleagues, we take a look at all three types initially. So whatever's said now is about all three: misconduct, incapacity, and operational requirements. You can take a look there under point 5. It says the Act lists 3 grounds on which dismissal may be fair: conduct of the parties, that's misconduct; capacity, incapacity, and operational requirements. And then just to remind us, they say, and if you do fire people because of their race, their gender, their religion, their sex, their culture, and their belief, well, that's an automatically unfair dismissal. So in terms of this, colleagues, it's an important, aspect to bear in mind. All 3 forms of dismissal in this. They then go directly into misconduct. So I want you to switch your brain manually. I want you to think of misconduct. Of course, that's where the employee is at fault. They've been culpable. They are negligent. They're intentional. They know what needs to be done, but they haven't done it. So let's see what the Code of Practice says about dismissals for misconduct, and of course, by implication, your disciplinary codes. The first thing that the Code on Misconduct says is it says that the purpose of discipline is for employees to know and understand the standards that are required of them and to guide their behavior. This morning, I was just looking at what the law requires companies to do as a mandatory obligation to their employees. And of course, in the BCA, one of the things you have to put in writing is your employee's job title and the contents of the job, because that's a fundamental requirement in proving misconduct. Were they aware of it? And they should have modified their behavior accordingly. Then the code goes and says the purpose of discipline is corrective. It's mainly to look at a graduated series of disciplinary measures. So they're also reminding us that you can't dismiss for a first offense in many respects. Smaller and less serious offenses mean you need to take a graduated approach. The form and content of the disciplinary rules and procedures may vary according to the size and nature of the employer's business. Now, I want you to see this. Look at what they're saying. The form and the content of disciplinary rules and procedures can vary according to the size and nature of the business. So one of the examples that comes to mind is absent without leave. You know, in a smaller business, someone who's absent for 3 or more days could attract a dismissible offense, whereas maybe in a larger business, more than 5 days. That would be an example of how the content of the disciplinary rules could vary based on the employer's business. Another example would be for someone working in a financial environment where they are negligent. That would be much more serious than in an environment where maybe it's purely an administrative role in a different environment. So you need to be able to structure your disciplinary rules and procedures based on your specific business requirements. In your case, maybe your client's requirements. Smaller employers may adopt a less formal approach to discipline. Smaller employers, again, coming here and the code saying to them, don't be formal. You don't have to have all these written codes. You don't have to have all these written notices to attend, etc. Dumb it down, make it simple, make it agile. Disciplinary rules need to be made available to employees. And now look at point 5. It's preferable for employers, especially medium and large employers, to adopt written disciplinary rules and procedures. So look at what they're saying. They're effectively saying a smaller employer does not need written disciplinary rules and procedures in the detail that is required. Yes, you need employees to be aware of it, but you don't have to go into that granular detail. But they're saying medium and larger employers, there we would recommend a higher level of written disciplinary rules in the terms of procedures and sanctions, guideline sanctions. But then it takes it a step further once again, and it says formal procedures do not have to be invoked every time a rule is broken, but more serious infringements or repeated incidents may call for a final warning or dismissal. An employer may depart from these rules if there's a justification for doing so. So let's just recap. What are they saying about disciplinary action? They're saying, firstly, you have to make employees aware of the standards required of them. That's obvious. Give them their job title, give them their job specification and job content and job profile, give them their KPIs. That's a requirement. But then they're saying, depending on your business, the size and the nature, you could have different levels of formality in terms of the rules and the procedures. And again, they're saying for anything other than a dismissal, don't go formal. Don't invoke a formal procedure. You'll see the wording they use just now in that regard. If we carry on with misconduct dismissals, the Code of Good Practice then goes, and these are new provisions, it says an employee may be dismissed for serious misconduct if the misconduct renders the continuation of the employment relationship intolerable. Now, intolerability, colleagues, is not a new concept. We do know that when the relationships become intolerable, we can dismiss. But you'll see throughout the code, where there's intolerability, they're giving you a greater legal right to dismiss than in the past. What's also interesting here, if you look at the bottom right-hand side, currently in Schedule 8, it says, generally it's not appropriate to dismiss an employee for a first offense, except if the conduct is serious and of such gravity that it makes continued employment intolerable. And then they even give you examples of misconduct where you could potentially dismiss. They talk about endangering the health and safety, damage to property, gross dishonesty, physical assault. You see, those examples are not in the revised code. And they're actually giving you as the employer more discretion. And they're saying, listen, it's not limited to dishonesty, damage, endangering the safety, or assault. We're telling you as the employer, if you can prove it's intolerable to keep John, you can go ahead and you can dismiss him. And yes, it's on the merits of each case, but it's not saying serious and of such gravity. It's just saying if it is intolerable. So I think in future, we're going to have better justification for dismissal on intolerability. Now, sticking with misconduct, as we know, you need to prove certain things in a disciplinary inquiry. And this is where there are some additional requirements now. So far it's been great for business, but now they've included points C and D. So before you dismiss someone for misconduct, firstly, of course, you need to ensure the employee contravened the rules. So you got to first prove there was a contravention. And if there was a contravention, you got to secondly, under 2A, prove it was a valid and reasonable rule. And thirdly, that the employee was aware or could have been reasonably expected to have been aware. So that's unchanged. Now it goes and it includes paragraph C and D. They're saying, in addition to that, you must look at that rule in the context of your workplace. How important is that in the context of your workplace? Then I love the next one because it helps us. It doesn't only say you got to prove actual harm. It goes and it includes a new word called potential harm. So in other words, it might have been a near miss, or maybe there wasn't a consequence to that employee's misconduct, but it was very serious and it could have happened. They're saying you can treat that, even though it didn't actually happen, on an equal footing to the fact that if it actually happened. And I think that is a very, very important matter. Another provision that I absolutely love, look right at the bottom of this slide. Now, we know, colleagues, that consistency under point E is a key requirement to prove substantive fairness. But in this code, look at what they're saying here. Right at the bottom, it says consistency is a significant factor to be considered in assessing the fairness of a dismissal. However, inconsistency does not necessarily mean that the dismissal is unfair. And if the misconduct renders continuation of the employment relationship intolerable, you see there the word intolerable comes through again. Now, under the previous Schedule 8 of the LRA, if you couldn't prove that you consistently applied the rule, you would lose your dismissal case on substantive unfairness. This code is saying, yes, you need to be consistent. However, let's say you've been inconsistent in the past, but in this case, you can lead evidence that this employee's continued employment is intolerable. We will still see it as a fair dismissal substantively. So I think that's good for business. That's why I said in the beginning, a lot of this is good for business. And the challenge to you today is, how do you take this and amend your disciplinary procedures, amend your disciplinary codes in order to benefit from this? Because also remember, the more you innovate and the more agile you are, the better for your client because your customers and your clients can then have a more efficient and more effective service from you when these incidents arise. Then it says the sanction of dismissal is only appropriate, oh my goodness, here's the word again, if the employment relationship is intolerable. Okay? Intolerability. And I think what we can see is almost a shift in labor law to say the ticking of the boxes, the legalities are starting to become less determining of fairness and reinstatement. What's more important is the relationship. If the relationship has been, contaminated and you can't be expected to work with anyone, well, then, of course, you shouldn't be forced by a commissioner or the court to continue working with them. Take a look at this provision over here. And now under point 4 says, any acknowledgement of wrongdoing by the employee and willingness to comply with the employer's rules or standards. What are they saying there? They're saying when you've chaired a disciplinary inquiry and you're looking at the sanction, they are telling you you've got to take a look at remorse. What does remorse look like? Colleagues, remorse looks like the employee pleading guilty in the first instance and acknowledging guilt. And secondly, remorse is where, as part of the employee's evidence and as part of the employee's mitigation, the employee voluntarily and unconditionally commits to complying with the organization's standards. And what the Code of Good Practice on Dismissal here is saying to you is they're saying we have to ensure that you pay more attention to remorse, because that's again part of the relationship issue. Okay. You see the current wording, if you look at the bottom right-hand side, it says when deciding whether to not impose the dismissal penalty, the employer should, in addition to the gravity, consider circumstances, length of service, etc. So that's still in there. Then it says the employer should apply the penalty of dismissal consistently with the way in which it's been applied to other employees in the past. You see, that's what the current wording does, but the new wording takes consistency into a new dimension and says, even if you're inconsistent, if you can prove it's intolerable, you can dismiss. Well, colleagues, that is the approach to misconduct in terms of substance. Let's take a look what this Code of Good Practice now talks about in terms of procedure. Now I want you to see how the tone changes. Let's first take a look at the current Schedule 8 on the bottom right-hand side. The current Code of Good Practice on misconduct in terms of procedure says normally the employer should conduct an investigation to determine whether there are grounds for dismissal. This does not need to be a formal inquiry. The employer should notify the employee of the allegations using a form and language the employee can understand. The employee should be allowed an opportunity to state a case in response. Now, just take a look at the wording there. Opportunity to state a case in response. You're starting to now see evidence in chief coming through. Maybe cross-examine. The employee should be entitled a reasonable time to prepare the response and to be assisted by a trade union representative or fellow employee. After the inquiry, the employer should communicate the decision and furnish the employer the written notification of the decisions. You see, colleagues, look at point 3. If dismissed, the employee should be given reasons for the dismissal. That is the current provision. Listen to the change in the wording of the new proposed changes, the new draft. It says the purpose of a fair procedure is to ensure a genuine dialogue and an opportunity for reflection before any decision is taken. Can you see the contrast between ensure a genuine dialogue and reflection compared to opportunity to be heard in response to the allegations? You see, they decriminalizing it. They say a fair procedure is one where the employee's been given an adequate opportunity to respond to allegations. And an investigation does not have to be formal. It must be appropriate to your circumstances and including the type of allegation and the nature and size of the employer. So I can already think in my mind of a number of options for you to amend your disciplinary code and procedure to build in a less formal, quicker, and less, onerous, less resources, less record keeping, smaller and more succinct findings of disciplinaries, where not even maybe recording it potentially. And then it says down in subsection 4D, where reasonably possible, be provided with an opportunity to converse in a language the employee is comfortable with. So this whole issue around interpreters, you only require it where it's reasonably possible. And allegations need to be made available or explained. So insufficient detail. You don't need these long-winded charge sheets and all this evidence and allegations. They want you to do genuine dialogue and an opportunity for reflection. It says, however, an employer may be obliged to justify non-compliance if the employee refers a dispute about the procedure. So if you do amend this and you make it more agile, innovative, and less resource consuming, well, then just justify it. How do you justify it? Will you base it on the size of your business, the nature of the offense, the systemic challenges, etc. And especially in your environment as a TS, your clients' demands. Your clients put demands on you in respect of this. They then go to the issue of unprotected strikes. Now, I'm sure all of you have dealt with illegal or unprotected industrial action. And of course, the first thing is you just start becoming really anxious because you're actually not sure what the detailed procedure is to deal with an unprotected strike. So what we see in the new code of practice in part 12 is it talks about dismissals and industrial action. And it gives you more detail. It says participating in a strike, and look, they've added the words that does not comply. So it's unprotected strikes with the provisions, of chapter 4 is misconduct. So they're saying unprotected industrial action is misconduct, which is what we're busy with. However, it doesn't always deserve dismissal, does unprotected strikes. The substantive fairness of dismissal must be determined in light of the facts of the case, including. So now we look at substantive fairness of unprotected strikes and the information that you need to gather and recordings that you need to ensure that you follow a substantively fair process. Now, the code of practice says, well, you've got to look at the seriousness of the contravention of this act. Were there any attempts to comply with the act? In other words, if it's a dispute of right, did they try and refer a matter to the Labour Court or the CCMA? If it was an internal grievance-based thing, did they follow internal procedures? Did they make attempts to comply? Did they refer the matter to conciliation before going on strike? Point C, whether the strike was in response to, and look at what they've included now, unlawful, unfair, or unreasonable conduct by the employer. In other words, colleagues, I've put the word provocation on the bottom right. I've just put that in there. But they are putting in section C, subsection C, and they're saying to you, as the employer, when dealing with an unprotected strike, you've got to introspect. And you've got to ask yourself, did we as the employer do anything to create anger and resentment to incite or provoke people that have gone on this unprotected action? And that's very important. It could be unlawful demands, so making people work in environments that are hazardous or longer hours than is allowed in terms of overtime. That would be unlawful. Unfair. Unfair might be potentially a shift change without giving reasonable notice. So, this is what the Act is saying, and they've included here, and the code is of conduct on dismissal is saying Be careful, employers, because sometimes you have a hand in provoking this. It then goes and adds this whole new section in now. It says factors relevant to assessing the seriousness of this contravention include the conduct of the parties to the dispute related to the strike. So they're saying, look at their conduct. What are they doing? Are they damaging property? Are they, engaging in hate speech? What are the conduct of the parties and, the bearing of that on the seriousness thereof? Are any of their demands potentially legitimate? The duration and the timing of the unprotected strike. So obviously, the longer it continues, the more serious it becomes, and then the harm being caused by the strike, the balance of harm. So I think the first thing that this code of good practice does as it adds in more detail so that we as employers can get a sense of substantive fairness. We need to answer to these things. So if you've got a contingency plan as a TES and your client wants to see your strike contingency plan, this has to be an integral part in assessing the extent to which they are not complying, the extent and the gravity of the misconduct. Still on the issue of unprotected industrial action, it now turns its attention to the procedural requirements. And this is a wonderful, wonderful exposition, colleagues, of how to deal procedurally with an unprotected strike. So it says, before you dismiss these unprotected strikers, you should at the earliest opportunity contact a trade union official to inform the trade union about the strike. But look at what they've added in: to afford the trade union an opportunity to consult with the striking employees. The previous code was less, detailed. This amended version says allow the union to consult. Okay, it's not just notify the union. You've got to allow the union within reason to engage. You should consider representations by the trade union official and discuss your course of action with a trade union official. If there's no trade union, obviously you've got to do that with leaders or representatives nominated by the strikers. Then issue an ultimatum in clear and unambiguous terms and give sufficient time to reflect. You see more detail coming into these codes. It then takes that ultimatum and it says, if you issue an ultimatum in point F to employees engaged in an unprotected strike, it may not be fair to dismiss employees for participation in that strike who obey the ultimatum and return to work within the stipulated period. You've got to be careful with your ultimatum, because if you say, if you don't return by 8 o'clock tomorrow morning, you're going to be dismissed. The point is, if they do return, and you've said that, you can't dismiss. You've got to say, if you don't return by 8 o'clock the next morning, and you don't have a pre-existing similar warning, you won't be dismissed. See, you've got to be careful how you word these ultimatums. And if the employees then reject your ultimatum, you may dismiss the employees after considering any representations and the conduct that they've engaged in as set out in the previous slide. So for me, it's very, very clear. We often wondered how many ultimatums, first ultimatum, second, final ultimatum. Here they're saying, listen, point 1, introspect. Take a look at the seriousness of the conduct and the impact it's having on the business. Secondly, in terms of procedure, get hold of the union, allow the union official to consult with the striking workers. If there's no union, let them elect representatives. Then issue the ultimatum if they don't return to work after that. Make sure the ultimatum is clear and unambiguous, and make sure that if people do return to work and you said you wouldn't dismiss them, then comply with that particular undertaking or word the ultimatum in an appropriate manner. And then ultimately, colleagues, they say, if they reject the ultimatum, you can dismiss. How do you dismiss? That talks of that in point H. Collective misconduct. You can then satisfy the requirements of procedural fairness, calling for collective representation. So you can have a collective disciplinary inquiry with representatives of the strikers, and you can have a collective dismissal. So this is a very, very useful inclusion in the code of practice on dismissal. Of course, you've got to keep disciplinary records. They say you should keep them, and you should specify the nature of disciplinary action taken. Okay, under POPI, of course, colleagues, please remember, you need to keep your disciplinary records for at least 3 years after the disciplinary inquiry. We now move to probation. So we've closed off on misconduct, as well as including unprotected industrial action. We now move to probation. Now, take a look at the wording under probation. An employer may require a newly hired employee to serve a period of probation before the employee's appointment is confirmed. This is new wording. So they say when you're on probation, your appointment is not confirmed. And I think you should use this wording when you modify your employment contracts around probation. Say, we're not confirming your appointment until such time your probation has been successfully completed in alignment with the provisions of law. It then says that the purpose of probation is to give the employer an opportunity to evaluate the employee's performance and suitability for employment before confirming this. So what you see here is they're saying probation is not just to see if the employee can perform, but if the employee is suitable. In other words, compatible. Does that person align with your culture of client centricity? Does that person align with your culture of urgency and align with your culture of integrity and honesty and whatever your culture is? You see, they're saying that. They're then saying probation should not be used to contravene the provisions of law to just deny permanent status. So you can't appoint someone on probation and extend and extend and extend it for unjustifiable reasons. So you can't dismiss them at the end of their probation if it's for a reason unrelated to their performance or suitability. But I want you to understand, as I said earlier, colleagues, the amendments to the Labour Relations Act will allow you in the first 3 months, once it is promulgated and gone through Parliament, to dismiss in the first 3 months for any reason, as long as it's not related to automatically unfair dismissal issues like race and gender. It says the period of probation should be determined in advance and be of reasonable duration. It's not 3 months. It's necessary for the time required to determine the suitability for continued employment. Now, colleagues, when we take a look at probation, it says that during probation, you need to give reasonable guidance, okay, which may include, not should. You see, if you look at the bottom right-hand side, under probation currently, it says if the employer determines the employee's performance is below standard, you should advise the employee of those areas. And, you should then allow the employee to make representations and have a trade union representative or fellow employee. But here in subsection 18, it says, if you don't want to confirm the appointment after probation, an employer may only decide to dismiss or extend probation after the employer has given the employee an opportunity to make representations and considered representations made. You see, it's a lot less formalistic than is currently the wording on the right-hand side. And interestingly, it doesn't even require you to allow the employee to have a trade union representative. It just says, has given the employee an opportunity to make representation. Interestingly, is in the wording of the draft code, it says the courts have accepted this to be a clear indication that arbitrators should be hesitant to interfere with your decision as an employer on whether the probationary employee has attained the required standards. In other words, The Code of Good Practice on Dismissal is saying to commissioners, they're saying, stand back. In the probationary period, the employer is best positioned to determine whether or not someone is performing or suitable, unless the employer dismisses them for factors unrelated to performance and unrelated to their suitability. You should not get involved in the decision of the employer. So it means there are less compelling reasons that, people on probation can be dismissed for. Of course, after probation, colleagues, you still have to follow similar processes in terms of that. So in terms of after probation, the only big change in terms of incapacity, dismissal due to incapacity, is that if you have to prove as the employer that the performance standard was reasonably achievable, that wasn't previously in the Code of Good Practice. So in future, when you dismiss someone for poor performance, you don't only have to prove they failed to meet the standard, they were aware of it, that you trained them and gave them an opportunity. You'll also have to prove reasonable achievement. And employers need to be even more careful that the key performance areas and key performance indicators are reasonable. There's no point setting unachievable targets and unreasonable, because it will make your dismissal unfair for poor performance. Now, this is quite interesting when it comes to incapacity and poor performance. Look at what they say about senior people. They're saying when it comes to matters related to performance, the employer may not be required to warn an employee if their performance does not improve. They might be dismissed. This may be the case for managers and senior employees whose knowledge and experience allows them to judge whether their performance is adequate. This is very, very important. And you should work this into your policies and procedures. If what they're saying here is when it comes to incapacity or poor work performance, when you dismiss people for poor work performance, if the person is senior, or if their person is someone who is a specialist and they should have the experience in that position, it says you shouldn't be required to warn them. They should know that if they don't meet budget, they should know that if they don't meet the service levels, they should know that if they don't meet the standards required, that it's serious. So you could basically, for senior employees and employees who should be more experienced, you can avoid even evaluation, instruction, training, counseling, and guidance. You can avoid that if it's a senior employee and literally go straight into an incapacity inquiry. That's a massive, massive benefit for employers, especially for senior people who've got a big impact on the organizational culture and performance. Colleagues, what I also find very interesting, and you've got to listen to this. I know it's a lot of detail and your brain is probably elsewhere. You're probably doing emails. If you're doing that, I want you to please come back and listen to this amendment. Under the heading of incapacity, right? Incapacity, you see it over there? Under the heading of incapacity, they've now included 2 new forms of incapacity. They've included, firstly, incarceration or imprisonment. And secondly, incompatibility, where people don't fit into the business culture of the employer. So let's deal with imprisonment or incarceration. Previously, when an employee was arrested and imprisoned, either pending bail hearings or pending trial, we were very uncertain as to how to deal with this because, is it misconduct? Is it incapacity? Is it operational requirements? What process do we follow? And here the code is very clear. They're saying if someone's in prison, the first thing you've got to do is you've got to try and get hold of them. Remember the aude alteram partem rule. So you've got to get hold of their family members, their legal representatives, or their trade union rep, And you've got to issue them with correspondence. And you've got to say to them, look, we're aware of the fact that you've been incarcerated. We're aware of the fact you're incapable of doing your job. It's not misconduct, it's incapacity. We've got a business to run. These are our challenges. What is your response in terms of duration, estimated timing? What is your response in terms of alternatives we can consider as alternatives to dismissal? Is there someone you'd like to attend your incapacity investigation if we have one? You see, you're going to have to prove that you've tried to correspond and give that employee an opportunity to respond. Based on that process, you can then go into an incapacity hearing under the heading of incapacity due to incarceration, and you can then make a decision to dismiss or look at alternatives to dismissal based on the submissions made by that particular employee. Of course, incompatibility, the same principle. You know, if someone's incompatible, our strong recommendation is you get statements from employees, from colleagues, from team members, maybe even put them through some form of personality or ego state assessment and get instances of where you can prove that that particular individual is the antithesis of what you stand for as an organization, and then bring them into an incapacity process. You know, it's a softer issue, but it's often harder to prove. Now the code of practice is giving you more confidence. They're saying to you, don't keep toxic employees on. If they're toxic and they're not fitting into your culture, well, here's a process. Deal with them going forward. Colleagues, the third and final component of the code of good practice on dismissal is the inclusion of this whole new section called operational requirements. It's still in section 189 and 189A of the LRA, but they've taken it and they've built outwards and they've given you more guidance and more detail on operational requirements. So as you can see on the screen, this is all brand new in the draft code. It obviously says you can retrench for technological, structural, or similar needs. Of course, economic, structural, and technological, they've added or similar needs, because historically, retrenchments in Section 189 really were economic, technological, or structural. So we see it happening around us big time. We see retrenchments taking place because of the poor economy. We see the imports of Chinese vehicles. We see the textile industry in trouble. So there are deeply rooted economic, technological, and structural realities. Temu, Shein, you know, drop shipping, platform-based workers, companies are busy restructuring continuously. I see Ster-Kinekor also closed down I think their gateway branch in Umhlanga because of their inability to continuously evolve and iterate and innovate. So then the Code of Good Practice says that you can't define all the circumstances that can legitimately form the basis of retrenchment. You know, and then they talk about economic reasons relating to the finances of the employer, technologies, new technologies, et cetera, et cetera. You know, so they talk broadly and in simple English around that. And then in subsection 3, they say because retrenchment is a no-fault dismissal, and because of its human cost, the Act places a particular obligation on the employer, right, to ensure that all possible alternatives to dismissal are explored. So colleagues, they then have a long section talking about the reason, what are justifiable reasons. They've even given you, if you look at the yellow area, the notice of the operational requirements. So you can take a look over here. They've got an Annexure A. And Annexure A actually sets out the Section 189, subsection 3, what should be contained as a minimum in a Section 189 notice of a possible or contemplated operation requirements process. So you can see they're making it a lot simpler and they're making it a lot easier for you to comply and giving you more confidence in that regard. So effectively, colleagues, what I'm asking you today is, given what we have covered, what is your approach going to be to reviewing not only your disciplinary code, but also your incapacity process? If you do have an incapacity process and policy, you need to include incompatibility, incarceration. What is your enhancement going to look like? What is your innovation going to be going forward? You know, just for example, currently your procedure might look something like this in a disciplinary inquiry. Preliminary investigation, evidence, suspension, charge sheet, proper notice, impartial chairperson, opening statement, you know, evidence in chief, cross-examination. So maybe your current disciplinary code has got all of these legalistic, criminalized processes where you got all these documents which are time-consuming and costly. I mean, paid suspension pending a disciplinary, your clients don't pay you for that. In most instances, you covering that cost. Okay. So what could your future one look like, given what we've discussed? And it's not an easy 1, 2, 3, this is what we can change. You've really got to think it through. You've got to design something that is meaningful. Now, sometimes, colleagues, you can make basic changes, intermediate or advanced changes. But remember, a lot of it depends on the size of your business, the structure of your business, the available resources, and even what's quite interesting, and I didn't tell you this, in the Code of Good Practice, they even suggest the use of technology in order to expedite disciplinary processes. So, you know, in light of that, colleagues, that is really what is, you know, what the Code of Good Practice on dismissal suggests in terms of the way forward. Now, what I want to do as we wrap up today's session, and I'll maybe just go off the slides for a minute and take you into, you know, maybe some practical examples of this. I want to quickly take you into the just into an example. I'll pull it up on the screen in a minute. Just give me a second. So, you know, given all of this information and given these potential changes to the Code of Good Practice on dismissal, the question I have for you is, you need to wrestle with this. You need to make sense of it, and you need to see how you can use these changes to your advantage going forward. You need to modernize your approach to this particular process. So, colleagues, you just give me a minute. Promise you I'll be with you shortly. I have a really very bad connection. I'm busy traveling, so as usual, I'm sitting in some less than optimal environment for me to do these things with you. So it's just loading very quickly. Maybe in the interim, while it's loading, I can take a look at the chat box. I did a huge amount of talking, so let me just try and see if there is anything in the chat box. Right, okay, thank you very much. I see there are some questions in the chat box. Good morning again, Nicole. If we take a look at Zenzo, what constitutes the size of the business? You know, let's define that. So what we do know is that smaller businesses are going to definitely have a different level of strictness in terms of disciplinary action in particular. They do not define a small business, but I would assume that a small business would probably be a business, you know, if you look at the Employment Equity Act, you know, if less than 50 people, Maybe it's a small business in terms of turnover. Maybe it's a small business in terms of that site. So Zenzo, what is required here is you've got to look at the structure and the nature of your business, and maybe just, consult with some stakeholders and see how you can define for yourselves what the size is in your business. I believe, for example, as I said, there could very well be an argument on some of your contracts to use that as a basis to modify your disciplinary codes and procedures. What would it mean that after probation there should be another notice that confirms permanent appointment? I'm not saying there's got to be another notice. What I'm just saying, though, Johannes, is that probation specifically means that we haven't confirmed your ongoing employment. So when you word your probation clause, you need to be very, very clear that the period of probation is there to determine, firstly, performance, and secondly, suitability. And that until that that probation period has been successfully completed, you cannot confirm their ongoing employment. I think that's all I was saying. It's just to be very, very clear that they are not permanent when they're on probation. The permanency gets confirmed once it's been successfully completed. Limited duration contract, obviously, as I said, I think you're going to have to take a fresh look at your limited duration contracts. I think that you're going to have to build probation into your limited duration contracts if they're not in there yet, as a matter of standardizing them, because as I said, the LRA amendments, which are different, which are not these amendments, this is just the code of practice on dismissal. But once the LRA amendments have gone through the parliamentary process, I can guarantee you that they will include a provision, as I said, in the first 3 months, that you can dismiss without following any major procedure or any significant substantive justification. So that's why some of the trade unions have been going to media saying that they've got a big problem with that, because it undermines the workers' rights. Okay. Right. Can I still issue the employment contract to employees under probation? Absolutely. You have to. I just think that you need to use probation much more effectively going forward. So with that in mind, colleagues, I want to encourage you. Okay, I don't know if you heard that, but I want to encourage you to look at using technology effectively in this space. So I'm quickly going to do a bit of a demo. As I said, the code does talk about using technology effectively, and I'm just hoping that I put my video feed off, that my connection is suitable for this quick demo. If it doesn't work, then it's fine. Can I just confirm, Lisa, that you can see my screen?
Yes, John, thank you. We do.
Thank you very much. So let me give you an example of one of the ways you can expedite this. Some of you have seen this. It's a disciplinary inquiry robot, right? So I'm just going to use a silly example, right? So it says, welcome to this disciplinary process. I'm here to help you. Why don't you just type in what happened? So I'll just say John used his lunchbox. And this was an actual labor appeal court matter, so I'm just changing, just abbreviating this. John used his lunchbox strap. His wife packs so much food in his lunchbox that he's got to use a strap to keep it closed. John used his lunchbox strap to smack a female employee on the buttocks during tea time at work. Okay, so let's say that's, now imagine your site supervisor, there's been an incident. John has now gone and smacked a female employee on the buttocks using his lunchbox strap, right? Okay, and this is where it says, thank you, I've noted this incident. Please upload the evidence. Well, I'll say I've got CCTV footage. I've got a code of, sorry, I've got a policy on harassment. And I've got a witness that was present. And I'm going to say the witness was Lisa, who was present, right? So I upload that. It says, thank you, John. I've noted that. Now it says, please upload your disciplinary code. Now, the good thing with this, colleagues, is if you are aligning your disciplinary codes to those of your client, right? If that is what you are doing, then of course you want to have the ability to upload your client's particular disciplinary code. But for purposes of today, I've just used a generic disciplinary code. I've uploaded it. And as you can see, this robot with my poor connection is now busy formulating charges. Obviously, you would have uploaded witness statements, etc. But here you can see it gives me charge 1, sexual harassment. You are charged with sexual harassment by inappropriately touching a female employee without consent. And it gives you the section of your disciplinary code. And it even tells you this charge is supported by CCTV footage, Lisa, who was present. It violates the harassment policy, etc. So, you know, you can ask it to do that, or can give you 2 more charges if you ask it to. Would you like to edit these charges? No. Would you like me to recommend to suspend the accused? Let me ask the bot to recommend if John should be suspended given his conduct. Here it says, you know, based on the information provided, we would look at the potential sanctions. The potential sanction is dismissal for the first offense. And then it says the risk level is high. And then effectively it uses potential for interference with evidence and the witnesses. And after looking at all of these factors, colleagues, it says we would recommend, I think it would recommend, it says it's a breach of trust and professional conduct. And our recommendation is based on the analysis. I would strongly recommend precautionary suspension on full pay for John pending the outcome of the disciplinary inquiry. Based on the seriousness, the risk to other employees, other female employees, the potential for witness interference, to demonstrate the company's commitment to addressing sexual harassment, and it gives you a justification. Would you like to proceed with the suspension? I say yes, I would like to proceed with the suspension. Would you like me to draft one? I say yes. Because remember, the POPI Act doesn't allow you to automate the entire process. It still requires human intervention. And there you go. It now drafts a letter of suspension that you can copy and paste onto your letterhead. Dear John, this letter serves as a formal notification that you're being suspended. Here's the allegation against you. And basically, it gives John an indication. You must remain available. You're prohibited from entering the premises. You mustn't contact the company's employees or clients, not the systems either. It's precautionary. It doesn't mean you're guilty, etc. So it gives you the whole detail in respect of that. Once it's given the letter of suspension, it will ask me, do I want it to draft the notice to attend a disciplinary inquiry? I'll say yes, please do draft it for me. And of course, there we go. It immediately uses that information and it gives a notice to attend a disciplinary inquiry. As you'll see, it includes all the necessary requirements, the date, the time, where it will be, the charge, sexual harassment, engaging in conduct unbecoming, breach of duty of good faith. Then it gives the employees rights, 48 hours notice, of course, as we've just said, I believe you can get rid of your 48 hours and do 24. I think you can even in simple cases do same-day inquiries off the back of this particular, off the back of this particular code of good practice that we've gone through. Even the right to an interpreter, I believe that you can say where it's possible. I don't believe it's an absolute right necessarily. Well, colleagues, there's the notice to attend the disciplinary inquiry. Then the robot asks me, do I want assistance in preparing an opening statement, cross-examination, and evidence in chief? I say yes. Of course, as I've just said, if you're a small company, it would say, would you like assistance in preparing a template for dialogue and reflection? Remember, that was the wording in the actual, code of good practice on dismissal. It now goes, it gives a full overview of the opening statement for this particular matter. And your initiator can obviously, print this out. There's the opening statement. It will then also suggest evidence in chief questions, open-ended questions to your own witness. And there we go over there. And then it will give questions for cross-examination. So you can see open-ended questions for evidence in chief. Can you explain the company's policy on harassment? How are employees made aware of it? And it even says these are specific questions for Lisa, the witness. So it actually recognized Lisa's role as having witnessed this. Specific questions for the security officer with the CCTV footage, and then questions for cross-examination of John. Even character witnesses, John's character witness in that regard. So colleagues, the reason I'm showing you this obviously is to show you how technology can be used. We also have one for disciplinary chair people that you can feed into the process. But this is the future of disciplinary action. You can see literally in a few minutes, we covered the entire exposition of the incident, evidence in chief, cross-examination, suspension letter, notice to attend. I think if you take the code of good practice, colleagues, and you then take away 48 hours notice, reduce it, you make anything other than a dismissal purely a dialogue, not a full inquiry, not a full hearing. Even with a disciplinary inquiry, you make it less formalistic, more dialogue focused, and then obviously you revise your disciplinary code and you really, really take a look at whether or not the sanctions across the various types of misconduct are appropriate in the context of that organization. So that is where we're at. Maybe in a future session, we can go through the actual labor law review. The labor law review is, as I've been telling you, it's been through NEDLAC. They've taken 2 years to get amendments to the LRA, the Equity Act, the BCA, and the National Minimum Wage Act. That's going through Parliament. It should be promulgated towards the end of this year. But there's some massive, massive changes coming through on those labor laws. But for now, more imminent is the Code of Good Practice on dismissal. I will forward the presentation, as I said, via the TSD offices to you, along with the code, and Krista can get that to you. With that, I'm going to hand back to Lisa, and Lisa, we can then wrap up. Thank you.
John, thank you so much for a great presentation and taking us through the LRA changes or the proposed changes in the Code of Good Practice for dismissals. I think it's really clear that the updated dismissal process is aimed to being more efficient and less demanding on the company's resources. And this said, one of the biggest challenges will likely be the human nature. I think we tend to stick with what we know, and changing the long-standing processes isn't always easy. The formal disciplinary process has long been seen as a safety net for employers. So moving away from this will definitely take some adjustment. That's also where the tools like you've shown us now for AI can really support employees, especially during the especially during the transition, and by helping to streamline the new approach and ensure consistency. I would just like to thank, I see that we've got a lot of CEA and CIFSA members on the webinar, as well as CEA and CIFSA EXCO members. Thank you so much, guys, for attending. And John, thank you again for presenting this important session to our members. And Krista, I'm handing over to you for closing.
Thank you very much, Lisa. Thank you, John. As usual, the presentation and the slides will be available from the TESD website and also our YouTube channel. So after the webinar, when it's available, I'll just circulate the notice to everybody and where to find it. Thank you so much for your attendance. Enjoy the rest of your day, and we'll see you at the next webinar.
Thanks, Krista. Goodbye, everybody.